The Companies Act 1956. Part 7, Winding Up. Chapter 5, Provisions applicable to every mode of winding up. Section 560, Power of Registrar to strike defunct company of register from register. Power of Registrar to strike defunct company name from the register. Power of Registrar to strike defunct company of register. Today, dear friends, let us focus our attention on refreshing ourselves the provisions available in section 560. The provisions enable us to understand the procedure registrar follows before striking off the name of the defunct company from register. How registrar will strike off the defunct company name from register? What would be the probable cause? The cause on which he believes to strike off the name of the defunct company from the register. Let us refresh. Section 560, Power of Registrar to strike defunct company name of register from the register. Subsection 1 of section 560 says, where the registrar has a reasonable cause to believe that a company is not carrying on business, or where the registrar has reasonable cause to believe that a company is not in operation, registrar of company shall send to the company by post a letter inquiring whether the company is carrying on business, inquiring whether the company is in operation. So, wherever the registrar of companies has a reasonable cause to believe that a company is not carrying on business, where the registrar of companies has a reasonable cause to believe that the company is not in operation, he shall send to the company by post a letter. What would the message is carried in the letter? The letter is inquiring whether the company is carrying on the business, inquiring whether the company is in operation. Here we need to underline one important point, where the registrar has reasonable cause to believe. Where the registrar has reasonable cause to believe, what would be the cause? There are different causes referred in the Companies Act 1956. Among them, you might have come across in Section 3 of the Companies Act 1956. Section 3 carries definitions of company, definition of existing company, definition of private company, definition of public company. Subsection 4 of Section 3 says, every private company existing on the commencement of the Companies Amendment Act 2000 with a paid-up capital of less than 1 lakh rupees shall, within a period of 2 years from such commencement, enhance its paid-up capital to 1 lakh rupees. Similarly, Subsection 4 of Section 3 says every public company existing on the commencement of the Companies Amendment Act 2000 with a paid-up capital of less than 5 lakh rupees within a period of 2 years from such commencement enhance its paid-up capital to 5 lakh rupees. Subsection 3 was referring private limited company which is having its paid-up capital less than 2 lakh rupees. When it comes to public company, subsection 4 says a public company which is having a paid-up share capital of less than 5 lakh rupees both need to enhance its paid-up capital within 2 years from such commencement of the Companies Amendment Act 2000 to enhance. Subsection 5 of Section 3 says where a private company or a public company fails to enhance its paid-up capital in the manner specified in subsection 3 or in subsection 4, such company shall be deemed to be a defunct company. Underline. We were referring cause to believe. Here, again underline, such a company shall be deemed to be a defunct company within the meaning of section 560 and its name shall be struck off from the register by the registrar of companies. See, we come across section 560 got referred in subsection 5 of section 3. Again, where a private company or a public company fails to enhance its paid-up capital in the manner specified in subsection 3 or in subsection 4, such company shall be deemed to be a defunct company. Such a company shall be deemed to be a defunct company within the meaning of section 560, underline, within the meaning of section 560, and its name shall be struck off from the register by the registrar of companies. So there is a cause when private company fails to enhance its paid-up capital after the commencement of the Companies Amendment Act 2000, or where the public company fails to enhance its paid-up capital within 2 years after the Companies Amendment Act 2000, such companies shall be deemed to be defunct companies within the meaning of section 560, and the name of such company shall be struck off from the register by the registrar of companies. So, to understand a reasonable cause to believe that the company is not in operation, that the company is not doing its business, we have referred section 3 of the Companies Act 1956. Let us go back to subsection 1 of section 560, where the registrar has reasonable cause to believe. Now, it may be easy for us to understand now a reasonable cause. Again, I am reminding myself that there are different causes available in the Companies Act 1956. Among them, I have referred section 3 to understand subsection 1 of section 560, where the registrar of companies has a reasonable cause to believe that the company is not carrying on business, where the registrar has reasonable cause to believe that the company is not in operation. The registrar of companies shall send to the company by post a letter inquiring whether the company is carrying on business, inquiring whether the company is in operation. So what was the cause? We refer one simple cause where the company fails to enhance its paid up capital. There are different causes. Many law cases refer many causes where registrar of companies strike off the names of defunct companies from register. Another cause may refer non-filing of annual returns and non-filing of balance sheet and profit and loss account. These are also valid causes for the registrar of companies to strike off the name of the company from the register. Let us go to subsection 2 of section 560. If the registrar of companies doesn't receive any answer thereto, he shall send to the company by post a registered letter referring to the first letter. From subsection 1 of section 560, we understood first registrar of companies will send a letter by post inquiring whether the company is carrying on business, whether the company is in operation. This is the first letter we come across from subsection 1 of section 560. In subsection 2 of section 560, we will come across understanding that the registrar of companies will send second letter, underline. This is second letter. If the registrar doesn't receive any answer to his first letter, if the registrar doesn't receive any answer to his first letter means first letter refer in subsection 1 of section 560. Then the registrar of companies shall send to the company by post a registered letter referring to the first letter. He refers the first letter in the second letter and stating that if the no answer thereto has been received by registrar and that the answer is not received to the second letter within 1 month from the date thereof, a notice will be published in the official gazette with a view to striking the name of the company from the register. Striking the name of the company of the register. So from second letter, we may understand the registrar of companies will refer his first letter and asks the company why they have not replied or given answer, stating that in the second letter that it has not received any answer, that the registrar has not received any answer. And if the second letter also doesn't get any answer, a notice will be published in the official gazette stating that it means the registrar will strike off the name of the company from the register. So from subsection 2 we are understanding registrar of companies on non-receipt of any answer for his first letter, he will proceed to issue second letter by registered post. The second letter refers to the first letter and also tells that the first letter has not received any answer from the company. ROC will also inform the company that a notice will be published in the official gazette. Regarding what? Regarding with a view to strike off the name of company from the register. Let us refresh again. Subsection 2 of section 560. If the registrar doesn't receive any answer thereto, he shall send to the company by post a registered letter referring to the first letter and stating that no answer thereto has been received, and that if an answer is not received to the second letter within 1 month from the date thereof, a notice will be published in the official gazette with a view to striking the name of the company off the register. Here we need to understand some important points. When does the registrar will send the second letter? He will send the second letter within 1 month. If he doesn't receive any answer within the 1 month, after that 1 month, within 14 days of the expiry of the month, the registrar will send the second letter by registered post referring to the first letter. And he also informs that he expects answer to his second letter within 1 month from the date thereof. These are the three important points, periods we need to understand. That is, registrar will wait to get an answer from the company for 30 days. 30 days of his first letter. On non-receipt of answer to his first letter, after passing 30 days, within 14 days, he will send second letter stating that to reply to his second letter, if he doesn't get any answer within 30 days, within 1 month from the date of second letter, he will issue a notice which will be published in the official gazette with a view to striking the name of the company off the register. These periods we need to remember. Subsection 2 of section 560. If the registrar doesn't receive any answer thereto within 1 month of the sending of the letter, this we need to underline again. Within 1 month of sending of the first letter, if the registrar doesn't receive any answer thereto, the registrar within 14 days of the expiry of the month, within 14 days of the expiry of the month, registrar will send to the company by post a registered letter referring to the first letter and stating that no answer thereto has been received if it has not received any answer to his second letter, and that if an answer is not received to the second letter also within 1 month from the date thereof, a notice will be published in the official gazette with a view to striking the name of the company off the register. This is second step in 560. Registrar of companies will follow before striking off the defunct company name from the register. Let us go to subsection 3. Subsection 3 carries provision relevant to subsection 2 of section 560. If the registrar either receives an answer from the company to the effect that it is not carrying on business or it is not in operation, or the registrar doesn't within 1 month after sending the letter receive any answer, there are three situations referred here. If the registrar receives an answer to his second letter that the business of the company is not there, that the company is not carrying on any business, that the company is not in operation, or If the registrar gets an answer that the company is not in operation, or if the registrar doesn't receive any answer within 1 month to his second letter, the registrar of companies may publish in the official gazette. What does he publish it? It is a notice and sent to the company by registered post, a notice that at the expiration of 3 months from the date of the notice, this notice is second notice we need to understand. First notice was referred in section 2. Here in section 3 it is saying he will send to the company a letter. He may publish in the official gazette who registrar of companies and send to the company by registered post a notice that at the expiration of 3 months from the date of that notice, the name of the company mentioned therein will be struck off the register and the company will be dissolved. Notice carries a message at the expiration of 3 months from the date of that notice. The name of the company mentioned therein will, unless cause is shown to the contrary, the name of the company will be struck off the register, struck from the register, and the company will be dissolved. Here we need to understand it is issuing a notice. ROC is issuing notice informing at the expiration of 3 months from the date of that notice, the name of the company therein will be struck off the register and the company will be dissolved. Again, subsection 3 of section 560. If the registrar either receives an answer from the company to the effect that it is not carrying on business, or that it is not in operation, or that the registrar doesn't within 1 month after sending the second letter receive any answer. If he doesn't receive any answer to his second letter within 1 month, the registrar of companies may publish in the official gazette a notice and send to the company by registered post a notice that at the expiration of 3 months from the date of notice, the name of the company mentioned therein will be struck off the register and the company will be dissolved. So from subsection 3 we are able to understand if the registrar of companies receives an answer from the company that the company is not carrying on business, that the company is not in operation, or if the registrar doesn't receive any answer to his second letter within 1 month after sending the second letter, the registrar of companies may publish in the official gazette and send to the company by registered post a notice that at the expiration of 3 months from the date of the notice, the name of the company mentioned therein will be struck off the register and the company will be dissolved. This is third step. We are able to understand from section 560. Subsection 1, subsection 2 and subsection 3 of section 560 enable us to understand the procedure registrar of companies will follow before striking off the name of the defunct company from the register. Subsection 4 is a bit different. Subsection 4 of section 560. It says if in any case where a company is being owned, underline. If in any case where a company is being owned, the registrar has a reasonable cause to believe either that no liquidator is acting or that the affairs of the company have been completely wound up. Again, if in any case where a company is being wound up, the registrar has a reasonable cause to believe either that no liquidator is acting or that the affairs of the company have been completely wound up, and any returns required to be made by the liquidator have not been made for a period of 6 consecutive months. Any returns required to be made by the liquidator have not been made for a period of 6 consecutive months. Then, the registrar of companies shall publish in the official gazette and send to the company or the liquidator, if any, a like notice as is provided in subsection 3. Subsection 4, 5, 6 are referring a simple cause where the company is being wound up. Let us go to subsection 5. At the expiry of the time mentioned in the notice referred to in subsection 3 or subsection 4, the registrar of companies may strike its name of the register. See in subsection 5, after the expiration of 1 month, the registrar will strike the name of the company or strike such name of such company from the register. That is what subsection 5 is coming forward to explain us. At the expiry of the time mentioned in the notice, at the expiry of the time mentioned in the notice referred to in subsection 3 and subsection 4 or subsection 4, the registrar of company may, unless cause to the contrary is previously shown by the company, the registrar may strike the name of the company of the register, and the registrar of company shall publish notice thereof in the official gazette, and on the publication in the official gazette of this notice, the company will stand dissolved. Again, the company shall stand dissolved. Subsection 5 carries two proviso, provided that the liability, if any, of every director, the liability of every director, the liability of every manager, the liability of every other officer who was exercising any power or management, and of every member of the company shall continue and may be enforced as if the company had not been dissolved. We may be having an understanding after striking off the defunct company name from the register, the managers, the directors, or the officers may not have any liability. Proviso to subsection 5 enlightens us it is not so. It is again emphasizing that even if the defunct company's name is got struck off from the register, the liability, if any, of every director, the liability of every director, the liability of every manager, the liability of every other officer who was exercising any power or management, and the liability of every member of the company shall continue. Underline the liability of every person. Every person means every manager, every director, every member of the company shall continue and may be enforced as if the company had not been dissolved. Another proviso is there. Nothing in this subsection shall affect the power of the tribunal or court to wind up a company, the name which of which the name of which has been struck off the register. Here we may understand another point. Nothing in this subsection shall affect the power of the court or the power of the tribunal to wind up a company, the name of which has been struck off the register on following the procedures of 560. Let us go to subsection 6. If a company or if any member or if any creditor thereof feels aggrieved by the company having been struck off the register, the tribunal on an application made by the company, on an application made by the member, on an application made by creditor, before the expiry of 20 years, understand, 20 long years after striking off the name, after striking off the defunct company's name from the register, if a company, if any member of the company, if any creditor of the company feels aggrieved by the company having been struck off the register, it may apply, company may apply to the registrar of companies. The member of the company may apply, the creditor of the company may apply. Before the expiry of 20 years from the publication in the official gazette of the notice, if satisfied that the company was at the time of striking off carrying on business or in operation or otherwise that it is just that the company is to be restored to the register, order the name of the company to be restored to the registrar. Here we need to understand very important point. Subsection 6 of section 560. If a company or any member or creditor thereof feels aggrieved by the company having been struck off the register, the tribunal on an application will come into picture. The tribunal or the court may come into picture. The company or the member of the company or the creditor of the company may apply to the tribunal or the court. When, before the expiry of the 20 years from the publication in the official gazette of the notice aforesaid, if the court feels satisfied that the company was at the time of striking off carrying on business or doing is in operation or otherwise that it is just, if the tribunal or the court feels it is just that the company be restored to the register, the court or tribunal may order the name of the company to be restored to the register. When does it take place? When the company feels aggrieved, when any member of the company feels aggrieved, when the creditor of the company feels aggrieved by the name of such company being struck off the register. One of them may approach the tribunal or court by application. On application to the tribunal or court, if it feels satisfied that the company was in operation, that the company was in business, or that it is just that the company be restored to the registrar, the court or tribunal may order the name of the company to be restored to the register, and the tribunal may give such directions and make such provisions as seem just for placing the company and all other persons in the same position as nearly as may be if the name of the company had not been struck off. The tribunal may also, by order, give such directions and make such provisions to the ROC as seem just for placing the company and all other persons in the same position as nearly as may be if the name of the company had not been struck off. This is what the court can do, or the tribunal can do it. When such a company approaches, when any member of company approaches, when any creditor of the company approaches to the court or tribunal, and if the tribunal gets satisfied, the cause shown by them, it can order ROC to restore the name of such a defunct company in the register, and it may also issue orders, it may also issue such directions and make such provisions as seem just for the placing the company and all other persons in the same position as nearly as may be if the name of the company had not been struck off. This is what we are able to understand from subsection 6 of section 560. Let us go to subsection 7. Upon a certified copy of the order of subsection 6 from the tribunal or court being delivered to the registrar of registration, the company shall be deemed to have continued in existence as if its name had not been struck off. Then the company will approach ROC with the certificate issued by the tribunal or court and request the ROC to restore the name in the register. Subsection 8 of section 560 says, a letter or notice to be sent under this section means section 560 to a company may be addressed to the company at its registered office, or if no office has been registered, to the care of some director, manager, or other officer of the company, or if there is no director, manager, or officer of the company whose name and address are not known to the registrar, the letter may be sent to each of the persons who subscribed the memorandum addressed to him. So registrar will send a letter informing that the name of the company is restored in the register. From 560 of the Companies Act 1956, on refreshing our results, we are able to re-understand the provisions of 560. Provisions were referring power of registrar to strike the name of defunct company from register. The procedures which registrar of companies need to follow before striking off the name of the company from the register under belief that the company is not in operation, that the company is not doing any business, and it comes to the conclusion that the company is defunct. There are different causes, therefore, in Companies Act 1956. Taking into consideration, the companies are deemed as defunct. Among them, we were referring section 3, section 159, 160, 161, and 162. And we also refer section 220, where the provisions are not complied. The ROC is going to take into consideration or non-compliance of such provisions. Registrar of companies may deem such companies as a defunct. and strike off the name of such companies from the register. Again, subsection 1 of section 560, where the registrar has reasonable cause to believe, where the registrar has reasonable cause to believe that a company is not carrying on business, where the registrar has reasonable cause to believe that the company is not in operation, the registrar shall send to the company by post a letter inquiring whether the company is carrying on business, inquiring whether the company is in operation. From the provisions of 560, section 560, we are able to understand that the registrar of company will send a letter to the company and it expects answer within 30 days. If the registrar of companies doesn't receive any answer within 30 days, after passing that first 30 days, the registrar of companies shall send second letter within 14 days informing the company that it has not received, means the registrar of companies has not received any answer to his first letter. If registrar of companies doesn't receive answer to his second letter within 30 days, the registrar of companies may issue a notice in the official gazette. This is what we are able to understand. It also says, at the expiration of 3 months from the date of that notice, the name of the company mentioned therein shall be struck off the register and the company will be dissolved. The company will be dissolved. Here we need to understand that the notice is not saying the company is dissolved. It is informing the company will be dissolved. When the company is going to get dissolved, that we are able to understand from subsection 5, that the registrar shall publish notice thereof in the official gazette, and on the publication in the official gazette of this notice, the company shall stand dissolved. See, the company shall stand dissolved. From subsection 5, we are able to understand the company shall stand dissolved when? After publishing second notice in the official gazette. From the first notice published in the official gazette, it informs us that the company will be dissolved. Company will be dissolved. From subsection 5, we are able to understand it will issue another notice in the official gazette stating that on the publication in the official gazette of this notice, the company shall stand dissolved. Underline, the company shall stand dissolved. This clarity many of us are having. There are two notices getting published in the official gazette. First notice carries a message that the company will be dissolved. Second notice gets published in the official gazette carrying on message that the company shall be not. In second notice, the company shall stand dissolved. This is what we are able to understand from the provisions of 560. There are many law cases wherefrom we may understand something more about the provisions of 560, where registrar of companies have not followed the procedures, the provisions of 560, how the case laws enable to understand us about the provisions of 560, we may understand now. Case law, Calcutta High Court, TC Audi and Sons Private Limited versus Registrar of Companies, dated July 16, 2009. again dated July 16, 2009 in the High Court at Calcutta, TC Audi and Sons Jewelers Private Limited versus Registrar of Companies. Here, the reason we may find from this judgment from the case law, let us understand. As it appears from the communication of the Deputy Registrar of Companies dated 24th March 2009, as it appears from the communication of the Deputy Registrar of Companies dated 24th March 2009, addressed to the company, the ground on which steps have been taken in the terms of Section 560, Subsection 3 of the Companies Act 1956 is that the company did not file statutory returns like balance sheets and annual returns for the last several years. What are we understanding from the preliminary lines in the case law? The Deputy Registrar of Companies found a ground. What is that ground? Registrar of Companies found ground basing its cause on the provisions of Section 560. It says that Registrar of Companies has not received any balance sheets or annual returns, that the company did not file statutory returns like balance sheets and annual returns. The company did not file statutory returns like balance sheets and annual returns for the last several years. So the Registrar of Companies has taken into consideration Subsection 3 of Section 560. Let us refer Subsection 3 of 560, where we can find, if the registrar either receives an answer from the company to the effect that it is not carrying on business, or the registrar doesn't within 1 month after sending the second letter receive any answer. See, this is the important point. Where it is not carrying on business means the company is not carrying on business. If the registrar either receives an answer from the company to the effect that the company is not carrying on business, or the company is not in operation, or the company or the registrar doesn't receive any answer within 1 month after sending the second letter, in such a case, the Registrar of Companies may issue a notice. Let us come to our case law. Here, Deputy Registrar of Companies says that the company did not file statutory returns like balance sheets and annual returns for the last several years. It is a different issue on finding. In the case law, it is realized materials have been disclosed by the petitioner, means by the company, Audi and Company, that filing of annual returns and balance sheets for 9 years up to till 31st March 2007 was there. See, annual returns were filed up till 31st March 2007. But whereas the Registrar of Companies base is reason that the company did not file statutory returns, it is proved later it is wrong. So far as filing of the annual returns and balance sheet for the year ending 31st March 2008 is concerned, so it has filed already annual returns up till 31st March 2007. When it comes for 31st March 2008, submission of the petitioner is that they wanted to file the same through the electronic medium but could not have access to the identification number of the company. It was only thereafter on examination they found that the name of the company had been struck off. So the company, the petitioner, has been filing annual returns in time, but it missed the notice of the Registrar of Companies. So let us go to subsection 3 of section 560. From the case law, we are able to understand that as it appears from the communication of the Deputy Registrar of Companies dated 24th March 2009, addressed to the company approached the Registrar of Companies requesting to understand the reason for striking off its name from the register. The Deputy Registrar of Companies from in its letter dated 24th March 2009, ROC informed the company that the reason for striking off the name is that the company did not file statutory returns like balance sheets and annual returns for the last several years. Whereas it is wrong, it is proved that the company has filed annual returns up till 31st March 2007. That's what we understood a couple of seconds back. It is further submitted by learned advocate appearing for the petitioners, means that is TD Audi and company, that no notice as contemplated in section 560 subsection 1, section 560 and subsection 2 was served upon the company before the impunge order was passed. So the registrar of companies need to follow the procedure available from the provisions of section 560. Registrar of companies did not follow the provisions of section 560. That is what we are able to understand from the advocate. Advocate is saying clearly that the registrar of companies has sent notice without observing the provisions of subsection 1 of section 560 and subsection 2 of section 560. Having heard the learned advocates appearing for the petitioner, I am prima facie, means that is advocate is prima facie satisfied that the impunge order by which the name of the company has been struck off was passed without complying with the procedure laid down in section 560 of the Companies Act 1956. Underline, without complying with the procedure laid down in section 560 of the Companies Act 1956. Without complying the procedure laid down in section 560 of the Companies Act. The impunge order, which appears to have been passed on 6th October 2007, shall accordingly remain stayed. We are able to understand from this case law, Registrar of Companies has not followed the procedures laid down in section 560. So without following the provisions of section 560, Registrar of Companies has proceeded to strike off the name from the register. This is what we are able to understand from the case law TC Audi and Sons Jewelers Private Limited versus Registrar of Companies, the High Court at Calcutta. Let us go to another case law to have more understanding about the provisions of section 560. This second case law is Bentech Bhatia Engineers Private Limited. Bentech Bhatia Engineers Private Limited versus Registrar of Companies. In the High Court at Calcutta, dated February 22nd, 2010. Case law, Bentech Bhatia Engineers Private Limited. Judgment dated February 22nd, 2010. Here, from this case law, we can understand the company has applied under section 560 subsection 6 of the Companies Act 1956 for restoration of its name of the register on the register after it has been struck off by the registrar of companies. So here the company has applied under subsection 6 of section 560 of the Companies Act 1956 for restoration of its name. Who can apply under subsection 6 of section 560 of the Companies Act 1956 for restoration of the name of the company struck off from the register? Let us have a refresh. Subsection 6 of section 566, if a company, if any member of the company, if any creditor of the company feels aggrieved by the company having been struck off the register, the company or member or the creditor may apply to the tribunal or court. When can they apply? Before the expiry of 20 years from the publication in the official gazette of the notice aforesaid. So 20 years period is there. Within 20 years, a company may approach tribunal or court. A member of a company or creditor of company may approach the court or tribunal to restore the name of the company in the register, so that the tribunal or court may order registrar of companies to restore in the register such a company name. That is what we are able to understand again from subsection 6 of 560. Now the second case law depends on subsection 6 of 560. Let us refer back our case law. The company has applied under subsection 6 of 560 of the Companies Act 1956 for what? For restoration of its name on the register after it has been struck off by the registrar of companies. The company has pleaded that the company had never received any notice prior to its name being struck off. See how pathetic situation is there. The company had not received any notice prior to its name being struck off from the registrar of companies. Though the company has admitted that the company had not filed statutory documents on a regular basis, it is a different issue. Company not filing statutory documents to the registrar of company is another issue. Whereas, before striking off the name from the register, the registrar of companies need to follow procedures laid down in section 560 of the Companies Act 1956. Whereas, the registrar of companies has not observed the procedures of 560. That is what we may understand from this case law. It says, the company has pleaded that the company had never received any notice. The company has pleaded that the company had never received any notice prior to its name being struck off through the company. Though the company has admitted that the company had not filed the statutory documents on a regular basis. There are 2 points in this sentence. One is the company is pleading that the company had not received any notice prior to its name being struck off. It's a very important point we need to understand, where lapse has taken place on the part of the registrar of companies. Let us go to second point in this case law. The registrar has used an affidavit which is completely vague and neither is a copy of the notice under section 561 appended to the registrar's affidavit. Here, the company has pleaded that it has not received any notice prior to its name being struck off. The registrar of company is saying it is wrong. It has sent a notice under section 560 subsection 1. but the Registrar of Companies has not appended any affidavit. So the reason we may find from this case law that the company has undertaken that the company will file all records and documents that are statutorily required to be filed within a period of 30 days from the date. Since the company has admittedly committed default in complying with the statutory requirements, the company will be required to pay costs. It is a different issue. The company has not filed some statutory reports. It has not filed annual returns. But before striking off the name from the register, ROC needs to observe the procedures of 560. It has not observed. The Registrar of Companies doesn't appear to have complied with the prerequisite of issuing a notice before striking off the company's name. This is another point from this case law we need to understand. Like this, there are various case laws where we come across lapses on the part of the Registrar of Companies not observing the procedures laid down in Section 560 of the Companies Act 1956. Let us go to another case law. Gemco Castings Limited versus the Registrar of Companies. Gemco Castings Limited versus the Registrar of Companies. The High Court at Calcutta. Judgment dated March 29, 2010. Very interesting case law it is. Here, the petitioners say that the Registrar of Companies did not serve any notice under Subsection 1 of Section 560, under Subsection 2 of Section 560, prior to the company's name being struck off. Again, very lapse is repeated in this case law also. The petitioners say that the Registrar of Companies did not serve any notice under Subsection 1 of Section 560 and or Subsection 2 of Section 560 prior to the company's name being struck off. See, this third case law also lets us to understand the very same lapse taking place on part of the companies, on the part of the Registrar of Companies. Let us go to another case law. Indian Explosives Limited versus Registrar of Companies. Indian Explosives Limited versus Registrar of Companies. Judgment dated April 21st, 2010. Recent judgment. From here we can understand the reason for striking off the name of the company from the register. This petition has been filed under Section 560 subsection 6 of the Companies Act 1956, seeking restoration of the name of HN Explosives Private Limited to the register of companies maintained by the Registrar of Companies. We have already come across such a case a couple of seconds back in Bentek Bhatia Engineers Private Limited, where the company approached the Registrar of Companies to restore its name. Here also it is similar, but here a creditor of the company is approaching to the Registrar of Companies to restore the name of the company. Reason for striking off the name, let us understand from this case law. The Registrar of Companies, that is the respondent herein, struck the name of HN Explosives Limited on the ground of non-filing of returns. Again, what is the ground? What is the cause? Non-filing of returns. Non-filing of returns. is the cause for the registrar of companies to strike off the name of the company. Here, the creditor of the company requests the ROC to restore the name of the company. Let us go to another case law. Chanakya Technos Private Limited versus Registrar of Companies. Chanakya Technos Private Limited versus Registrar of Companies, July 13, 2010. In this case law, the petitioner Chanakya Techno preferred his petition under subsection 6 of 560. It is similar to our previous case law of the Companies Act 1956. For what? For restoration of its name in the register on the ground that the company is an economically viable and is a running unit. Here, the company has approached for restoration of its name, saying that the company is an economically viable and is a running unit. It is ready and willing to set right all irregularities with regard to furnishing of the statements. Here from this case law we can also understand the reason for striking off the name from the register. Reason we are able to find out that non-filing of annual returns. It has also been avowed by the petitioner company that before making the above publication, it will not serve with any notice under subsection 1 of 560, subsection 2 of section 560 of the Act. Here again, we are able to find the very lapse. So till now, most of the case laws we refer, the reason is we are able to understand non-filing of returns one side. Another reason, another cause is that the procedures of section 560 are not observed on part of the registrar of companies. Let us go to another case law. Here, this case is Basant Cotton Mills 1998 Private Limited versus Registrar of Companies West Bengal. Judgment delivered on 8 August 2012. On reading subsections 1, 2 and 3 and 5 of section 560, it does seem to me, to the judge, that a company can only be a defunct if it doesn't reply to the notices or says in reply that it doesn't carry on any business or is not in operation. It says that the company shall be defunct when it doesn't reply the letters received from registrar of companies. If it asserts to the contrary, it cannot be struck off at all. Hence, striking off is on the admission of the company that it is defunct. The same principle applies in the application of section 3, subsection 3, subsection 4 and subsection 5 of the Act. It necessarily follows that if there is any dispute regarding the paid up capital or whether the company does business, it cannot be declared defunct. Moreover, the petitioner claiming to be a shareholder and director had sufficient locus to file this application. The order of the Registrar of Companies dated 27 January 2006 is set aside. The company be put back in the Register of Companies immediately by the Registrar of Companies West Bengal. This application is allowed. Here, the reason is subsection 4 and subsection 5 of section 3 is taken into consideration. Many of the case laws we have come across, a reason based on what ROC strike off the name of the companies is 1. Non-filing of returns. It has taken as a reason in some cases, in some case laws, and in some case laws we come across registrar of companies have not observed the procedures laid down in section 560 of the Companies Act 1956. Not observing the procedures of section 560 cause many case laws to take place. Again, may we understand, may we refresh again section 560 of the Companies Act 1956. Section 560, power of registrar to strike defunct company from register. Power of registrar to strike defunct company from register, or power of registrar to strike defunct company off register. Subsection 1 of section 560, where the registrar has reasonable cause to believe that a company is not carrying on business. Where the registrar has reasonable cause to believe that a company is not in operation. Registrar of company shall send to the company by post a letter inquiring whether the company is carrying on business, whether the company is in operation. This is subsection 1 of section 560. Let us go to subsection 2 of section 560 here. If the registrar doesn't receive within 1 month of sending the letter any answer thereto, he shall within 14 days after the expiry of the month send to the company by post a registered letter referring to the first letter and stating that no answer thereto has been received, and that if an answer is not received to the second letter within 1 month from the date thereof, a notice will be published in the official gazette. A notice will be published in the official gazette with a view to striking the name of the company off the register or from the register. So the registrar of companies may issue a notice. It may get published in the official gazette informing that it will strike off the name of the company from the register. Subsection 3 of section 560. Subsection 3 is relevant to subsection 2 of section 560. If the registrar either receives an answer from the company to the effect that it is not carrying on business, if the registrar either receives an answer from the company to the effect that it is not in operation, or the registrar doesn't within 1 month after sending the second letter receive any answer, if the registrar doesn't receive any answer within 1 month to his second letter, the registrar may publish in the official gazette and send to the company by registered post a notice. So he may send a letter, a notice to the company, and he also publishes in the official gazette. The registrar may publish in the official gazette and send to the company by registered post a notice. What does it carry? That at the expiration of 3 months from the date of the notice, at the expiration of 3 months from the date of that notice, the name of the company mentioned therein will, unless cause is shown to the contrary, be struck off the register and the company will be dissolved. The company will be dissolved. We need to understand the company will be dissolved. The company is not dissolved. You need to understand from this notice published in the official gazette, it is letting us to understand the company will be dissolved, So it shall stand dissolved, we may understand from different subsection. Let us go to subsection 4. If in any case where a company is being wound up, the registrar has reasonable cause to believe either that no liquidator is acting or that the affairs of the company have been completely wound up, and any returns required to be made by the liquidator have not been made for a period of 6 consecutive months, and the registrar shall publish in the official gazette and send to the company of the liquidator or the liquidator, if any, a like notice as provided in subsection 3. Let us come to subsection 5 of section 560. At the expiry of the time mentioned in the notice referred to in subsection 3 and subsection 4, that is 1 month, the registrar may, unless cause to the contrary is previously shown by the company, the registrar may strike its name of the registrar. The registrar may strike off the name of such company and shall publish notice. This is second notice you need to understand. The registrar shall publish notice thereof in the official gazette, and on the publication in the official gazette of the notice, the company shall stand dissolved. See, the company shall stand dissolved. See, from the second notice, we may understand that the company shall stand dissolved. From subsection 3, we were understanding the first notice will be published in the official gazette, and it was saying that company will be dissolved. When it comes to subsection 5, from the second notice being published in the official gazette, we are able to understand that the company stands dissolved. There are two provisos to subsection 5. We may understand many directors, many persons, many concerned officers of the company may think it is good to get dissolved. We may not feel liabilities. It may be the good reason to get strike off the name of the company from the register. The provisions of the Companies Act says, provision to subsection 5 says, the liability of any director, the liability of every director, the liability of every manager, the liability of every other officer who was exercising any power or management, and of every member of the company shall continue and may be enforced as if the company had not been dissolved. See this very important point. There may be some persons to evade their liability. They may get strike off their name by not filing their annual returns, or maybe on some other cause enabling the registrar of companies to strike off the name of their company from the register under the impression that they may come out from the liability. That is what is avoiding provision to subsection 5, provided that the liability of every manager, the liability of every director, the liability of every other officer who was exercising any power or management, and of every member of the company shall continue and may be enforced as if the company had not been dissolved, as if the company had not been dissolved. There is another important provision. Nothing in this subsection shall affect the power of tribunal. Nothing in this subsection shall affect the power of tribunal or court to wind up a company, the name of which has been struck off the register. Let us go to subsection 6 of section 560. If a company, assume that the name of the company got struck off due to one or other reason, there may be situations where a company may feel, or member may feel, or creditor may feel aggrieved on getting the name of the company struck off from the register. Regarding it, subsection 6 of section 560 enables, if a company or any member or creditor thereof feels aggrieved by the company having been struck off the register, the tribunal, on an application made by the company member or creditor before the expiry of 20 years from the publication in the official gazette of the notice aforesaid, may, if satisfied that the company was at the time of striking off carrying on business or in operation, or otherwise that it is just that the company is restored, to be restored to the register, and the tribunal or court may order the name of the company to be restored to the registrar. Here we are able to understand a company or any member of company or creditor of company feels aggrieved, they may approach the court or tribunal. We need to understand whom are they approaching, not the registrar of companies who struck off the name of the company from the register. They are approaching the court, they are approaching the tribunal to get restored the name of their company in the register by the registrar of companies. And the tribunal may, by the order, give such directions and make such provisions as seem just for placing the company and all other persons in the same position as nearly as may be as if the name of the company had not been struck off. Subsection 7. Upon a certified copy of the order under subsection 6 from the tribunal being delivered to the registrar for registration, the company shall be deemed to have continued in existence as if its name had not been struck off. Subsection 8 of section 560. A letter or notice to be sent under this section to a company may be addressed to the company at its registered office, or if no office has been registered, to the care of some director, manager, or other office of the company, or if there is no director, manager, or officer of the company whose name, address are known to the registrar, may be sent to each of the persons who subscribe the memorandum addressed to him. Till now, we are able to refresh ourselves about the provisions of 560, and we are also able to refresh by understanding some provisions from available case laws, where we are able to understand the cause for striking of the name of the company from the register. There are some lapses we are able to understand from the case laws. Lapses are on part of the registrar of companies, lapses are on the part of the companies. Among them, we are able to understand some lapses like non-filing of returns, sometimes non-observing the provisions of section 560 by the registrar of companies. It is good we are able to refresh again the provisions of section 560 of the Companies Act 1956. Section 560, Power of Registrar to strike defunct company off register. Power of Registrar to strike defunct company from the register. We are able to understand. Thank you, all of you.